Oldies, 98.9, 105.3 WGNY FM. On a fun day Saturday morning, I'm Bob O, a very, very special guest, and it's time for Planning Ahead with Megan Conroy. Megan, good morning.
Good morning. How are you?
Oh, doing great. How was your 4th of July, dear?
Wonderful. Really enjoyed those couple extra days off.
So you filled the grill, huh?
We did, that's for sure.
All right. So give us your contact information, Megan, which is very, very important, as you know.
Sure. So my name is Megan Conroy. I'm an attorney at Blustein, Shapiro, Frank, and Barone, located out of Goshen. The phone number there is 845-291-0011.
You're not just an attorney, you're a partner, Megan.
That's true.
Let's not leave that out of the mix. That's for sure. So it's planning ahead and what it's all about.
That's right.
And some people have to be very, very careful in making their decisions too. So, Megan, what's the topic today?
I thought we would continue to talk a little bit about using Medicaid as a payer for long-term care.
Oh, yeah.
So last time when we started talking about it, we were talking about how I think a lot of people don't realize that they can use Medicaid to pay for long-term care. And while there is some financial eligibility that they would have to meet, as part of a normal estate plan, you can actually make that eligibility a little bit more attainable for yourself.
Wow. So how do you go about doing that?
Sure. So whenever we're working with people who are starting to think about as they get older, they may or may not end up needing some level of care, whether that's an aid service coming to them in their home or assisted living facility or nursing home facility. These individuals are beginning to realize that cost is very expensive. So a good thing to do is to try to get ahead of that. And when you do your regular estate planning, usually we start to see this come up maybe around retirement age, maybe mid-60s. When you're doing your estate planning, or hopefully you're updating your estate planning at that age,
right.
People will start to ask me, is there any level of planning I can do for this expected cost in the future? And there is. Generally, we're using trust planning that will protect assets, so that the individuals further down the road, when they begin to need the care, the individuals can become eligible for Medicaid to pay for that care a lot more easily. And the trust works to protect and shelter assets so that they are not counted against them when they're applying for that financial eligibility requirement.
Now, Megan, is that 100% covered?
So the assets that go into the trust are 100% covered, provided that they meet certain time frames. So in New York, at least, we have a difference between what's considered community-based care, community Medicaid, and nursing home Medicaid. Now, in the community, meaning if you have an aid service coming to you in your home, or you're needing maybe assisted living, anything other than nursing home care, really, that's going to be considered community Medicaid. And the effectiveness of the trust that we use is immediate and 100%, meaning that when someone sets up that trust and puts assets into it, retitles the assets so that the trust becomes the owner, the following month, those assets are going to be off the table, ignored for purposes of qualifying for community Medicaid. And they're 100% protected at that time. For nursing home Medicaid, it's a little bit different, though, because there's something known as the 5-year look back, and a lot of people have heard about it. It used to be 3 years, it's 5 years. Some people think it's going to 7 years. It's not going to 7 years. It's staying 5. But the 5-year look back means essentially that when we put this trust together and we move the assets into it, those assets are not fully protected until they've been inside that trust for 5 years. So it will be 100% protected as long as those assets have been in the trust for 5 years before the person needs nursing home Medicaid.
Oh, wow. That's very, very interesting. So what,
Sure.
I hate to put it this way, but what if the individual his life is cut short before the 5 years?
Okay. So if an individual passes away before that 5-year period is up, the trust is still effective. The trust's secondary purpose is to help us to distribute assets, very much like a will would do, but a trust doesn't have to go through a court proceeding, which is known as probate. So the assets are passing to the named beneficiaries in the trust without any kind of court intervention. So if the individual passes away immediately after setting up the trust, before the 5-year period has expired, or after the 5-year period, the trust will still work to distribute assets. Where the trust would fail for that person is if they needed a nursing home within 5 years of setting it up. The trust hasn't had enough time to protect the assets at that point. And so then a different strategy would be used. We would mix it up, try to change and protect the assets a little differently. And so to your point, we do, in addition to proactive planning using a trust, we do, and attorneys can do, what's called crisis planning, meaning a lot of people didn't realize you can set up a trust to protect assets, so they don't call on the attorney until the last minute. They're suddenly needing the nursing home, and there is still a lot that can be done to protect assets, even at the moment that that person is needing the nursing home.
Oh, I see. So what was the title of that with an attorney? What was that called?
So we can do proactive planning using the trust, or we can do crisis Medicaid planning. If someone didn't realize that proactive planning was available, they're suddenly needing assistance right away. We do it in a crisis.
Oh, I see. And Megan, again, what is your contact information and where are your offices located?
Sure. So our offices, Blustein, Shapiro, Frank, and Barone, are primarily located out of Goshen. We do also have a Monticello office, the location there as well. The primary phone number for us is going to be 845-291-0011. We also have a really great website people can check out, kind of take a look at each of the attorneys in our practice areas. That website is www.mid-hudsonlaw.com.
All right, very, very important stuff. And, of course, you have workshops on and off throughout the year, don't you?
We do, and actually I only have one workshop left this year. It's going to be on October 14th. It starts at 3 o'clock that day.
Boy, I can't believe the holidays are right around the corner. Wow.
I know, this year has flown by.
It really, truly has. And the heat in the month of July has just been totally outrageous.
Oh, yeah. Very unpleasant for me.
Yeah, me too. I don't even go outside. My forecast is 99% couch with intermittent snacks.
I like that. I'll join you there.
Okay, you got that. So, Megan, this is very, very important, setting up this trust, right?
Sure. I do think it's going to be something that is appropriate for a lot of people. Not everyone has this concern. Some individuals are not as worried about long-term care costs because they have sufficient assets and income that they're willing to privately pay for the care, albeit very expensive, but some people are okay with that. There's also long-term care insurance policies that can help offset the cost. But for most people that live in our area, I would say that this kind of planning is something that is appropriate to at least discuss with a professional, with an attorney who practices in this area. And then, like I said, if you didn't realize it and it's sort of feeling like you're too late, you're behind the eight ball, it's never too late, at least in New York. New York happens to be a very good place to qualify for long-term care Medicaid. The way that the legislation is written and the options that are available to us give us a lot of tools so that we can still protect and preserve a lot of assets in New York where those options aren't necessarily available in other states.
So even if you're 73, 74 years old, you can still do this?
Sure you can. There's going to be a discussion about what your goals are, what your assets look like, and what your health is like at that time. Certainly 73, 74 is not old, but if you're telling me that you're already started to suffer from some severe health concerns and you're thinking that the care that you're going to need is going to come a lot sooner than that 5-year look back that we are generally concerned about, then maybe we want to consider some different avenues for you at that time. But otherwise, 70s, even 80s. I've done planning for people at all ages. It really comes down to what their goals are and what their health is like at the time they're meeting with me.
Really? Even in their 80s?
Sure. Oh, yeah.
Wow, that's awesome. That is absolutely awesome. So how long does it take to set up that trust?
So typically the trust itself, that style of planning, doesn't take incredibly long. Our process is pretty fixed on about, I'd say 6 to 8 weeks from start to finish. Our process does involve 3 meetings usually. It could be more if we have more to chat about. But typically we'll start with an initial meeting so that I can start to get some basic information about the client and see what it is that I might start recommending to them. And that's where we kind of sketch out what the plan might look like and make some proposals. Then from there we go to a second meeting. At the second meeting, we're going to spend a little bit more time focusing on the actual documents, the provisions that go into them. And then we schedule a third meeting, and at the third meeting is generally where I have those documents drafted, prepared. We're going to review them all together, make any changes if there are any, and then all the documentation would be signed at that third meeting. So typically for that, we'd see that happen over about a 6 to 8 week period.
Wow. So if you have a house that's all paid off, mortgage-free, does that make things easier?
For primary residence, it can make it easier. It doesn't make a lot of difference for the primary in particular. It could still have a mortgage on it, and you can put it in a trust and still work on protecting the equity. For secondary homes or vacation homes, though, I will say that if they're mortgage-free, it's a lot easier to protect those assets as well.
Oh, wow. Including vacation homes, huh?
Sure, yeah. I mean, they happen from time to time. We do get individuals that do have secondary residences, whether it's a cabin they inherited from, their parents or their grandparents ages ago, to maybe a condo in another state. As you can imagine, we have a lot of people who do what's called snowbirding.
Yes.
They spend some time in New York and then the rest of the time someplace a little warmer, although New York has been very warm lately.
Yeah, it has. Yeah, it has. So it doesn't matter if I'm a snowbird and I have a home in Florida and I have a home here then.
Sure, it doesn't matter. The thing that we'll want to focus on is which state is your primary residence.
Oh,
and
New
so,
York.
Like I said, New York, right. Yep. So New York happens to be a really good place for this kind of planning, long-term care planning. And so the planning opportunities that would be available to a person who still says, even though I have this place in Florida, New York is going to remain my primary residence, we can do a lot more for them under those conditions than maybe we could if their primary residence was in some other state. Now, I only practice in New York, so I can really only speak to the laws here. But I do know that there are some states that have very similar laws to New York, and then there are some that are wildly different.
So what if I have an asset that's in the state of Florida? Is there any problem there at all?
Typically, there's not a problem. If that asset happens to be real estate, then it's going to become a little more important that you do some solid estate planning. Because if you own assets in multiple states, and let's say it's going to be real estate in multiple states, and you don't use a trust or you don't rely on beneficiary designation, and we're in a position where those separate pieces of real estate need to go through probate, what you'll find out, or at least your family will find out after you're gone, is that they're going to need to go through that probate proceeding in each of those states. So now we're not just talking about one court proceeding, but we're talking about lots of little court proceedings in different states, depending on how many places you own real estate at the time you pass away.
And that takes a while. That takes a while with probate, right?
Great point. Yes, that can take a while. So typically, locally, we'll find that the probate proceeding usually occurs over the span of 1 year if there are no issues. Now, to get it going, you're going to find that it's probably about 4 or 5 months so that the executor can be appointed and really start to do some things, start to transact on behalf of the estate. And then from there, if we have several probate proceedings in multiple states, it's going to be called what's called an ancillary proceeding in each other state. And those are expedited versions of the same one-year proceeding. But still, you're going to find that whenever we go through a probate proceeding, we're talking about several months, if not a little over a year, to get that completed, start to finish.
Wow. You really have to have patience for that, don't you?
That's true. And, you think about it, it's coming at a time now where you've lost someone that you care about, and all you really want to do is move past it, get things wrapped up, kind of make sure that things are where they're supposed to be, and at no fault of yours, no fault of the attorneys necessarily, and even no fault of the court system, things are being delayed because it's going through this very regimented process, and the delays are just inherent in that. So it can be frustrating and confusing to family members.
Oh, I remember that story I told you about Uncle Joe. You remember that one? Boy, that was amazing, where he went to law firm number 1 and did a last will and testament. And several months after that, he didn't like the way law firm number 1 was, so he went to law firm number 2 and didn't even bother to tell law firm number 1. So he filled out another last will and testament at law firm number 2, which apparently superseded law firm number 1. And then what happened was that, law firm number 1 kind of got their nose out of joint. And even though they knew the law, they decided to take law firm number 2 to court to test the law. And, of course, law firm number 1 did not win because they wanted a percentage out of Uncle Joe's estate. Now, that really killed things for a while.
Sure, yeah. There's all kinds of delays that can come up when we're dealing with court proceedings. Now, that example, Uncle Joe's example, is pretty unique, but it does speak to the fact that anytime we go through this kind of a court proceeding, anyone who might think that they have some kind of claim or interest in the estate will have the opportunity to come in and say why, and that generally leads to more delays. So like I said before, in a probate proceeding, you might see it take about a year, but that's with no issues whatsoever. In Uncle Joe's scenario, we're typically going to find that this is now going to last much longer than a year because we have other parties involved, and the court has to do a lot of work to determine what's the truth, who is actually entitled to receive, whether it's a portion of the estate as a beneficiary or maybe professional fees or commissions because they did some level of work or thought that they should be responsible for some level of work, like law firm number 1. So unfortunately, there's a burden on the family and a burden on the court to sort all of this out and wait as it plays out.
Well, as it turns out, if people may remember, as it turned out, law firm number 1 didn't get their wish, and law firm number 2 was released as executors of Uncle Joe's estate. Instead, the court decided to appoint executors to Uncle Joe's estate, which in this case was his old company that he worked for 40-plus years.
Wow, very interesting scenario. So you don't typically see things like this when the decedent, the individual who passed away, like Uncle Joe, when they have family members that they elect to designate as their executors. But sometimes people don't have family members that they can depend on, or especially when we're dealing with maybe a higher net worth estate where there's a lot of different assets or a lot of monetary value associated with the estate. The individual might select professionals like a financial institution or even a law firm if the law firm is willing to serve, because they want to make sure that there is a professional handling all of these tasks rather than burden their family members. So Uncle Joe's situation is quite unique, but certainly speaks to the fact that these things can be very complicated, and it's important to do clear, concise planning with attorneys who do this kind of work so that they can anticipate those issues for you when my clients come in to see me, they don't know what they don't know, and that's okay. We don't expect them to. We just have to allow them to trust that we know what we're doing and we can guide them.
Well, from what I understand, a judge has to take his time and look all this stuff over and then make a big, huge decision as to what's going to be done legally, in particular about Uncle Joe's estate. And from what I understand, now I could be wrong, the judge had 3 choices for the executor of Uncle Joe's estate. And apparently he took Uncle Joe's company ahead of everything else, whatever that was.
Interesting. Yeah, so they must have done an assessment. The court in this case did an assessment to see what Uncle Joe's wishes were as they were outlined in his will, in the documentation, and then also taking into consideration who these parties are, right? Maybe he selected a series of different executors, and the court determined that while Uncle Joe might have preferred one or two, that they were not suited for the position. Maybe they had too much interest in the matter, or there was too much of a conflict in them representing the estate fairly. And so ultimately it sounds like they selected the employer, and hopefully, it's because they were able to demonstrate that they're a very good candidate to follow Uncle Joe's wishes, make sure that the estate is settled in the way that Uncle Joe would have wanted.
Boy, how complicated can you get? That's why that's why it really pays to make a proper decision and do your research.
Sure. I agree with that wholeheartedly. Do your research. It's always good to make sure that you have a general understanding of what it is that you're looking for so that you can properly describe what your goals and objectives are, and then also relying on those professionals that you select, right? Whether it's your attorney, your accountant, your financial advisors, these are people that should be involved in the conversations, and they should be able to guide you now to meet those objectives that you've described.
Let me ask you this question. In regards to Uncle Joe's estate and what we're talking about here, let's go back to the very beginning of our conversation. Now, what happens, what was it, Medicare? Medicaid. So what would happen in a case like this with the Medicaid deal?
Mm-hmm.
I mean, this would really complicate things on that, would it not?
It could. So the interesting thing about Medicaid is a government benefit, and you qualify for long-term care Medicaid by demonstrating that you meet certain financial criteria. So I don't know that Uncle Joe necessarily would have met this financial criteria, but let's say that he did. During his lifetime, he was able to do some strategic planning, and he got himself eligible for long-term care Medicaid, and I don't know for what duration he needed long-term care, but the Medicaid benefit helped offset the cost of that long-term care. Now when we go through this probate proceeding after he's passed away, Medicaid can actually become a creditor of the estate, and they can seek reimbursement from the estate assets, but only those assets that are passing through probate. And their argument there is, hey, we paid, let's say it's $100,000 for Uncle Joe during his lifetime. He had some care needs. We made sure that an aide came to him on a daily basis. All of these services that we've provided cost $100,000. Now that he's gone, we'd like to be reimbursed for that $100,000 that we've paid for his care, and we'd like that payment to come from his probate assets. And so that could really throw a wrench in Uncle Joe's probate proceeding, the estate administration after he passes, because now that we've sorted out who will serve as the executor's role is to make sure that Uncle Joe's debts are paid off before any other beneficiaries receive a distribution. And Medicaid ends up being one very large creditor of an estate if the person did receive services during their lifetime. So in that example, now that the executor is being appointed, they'd have to make sure they pay Medicaid back the $100,000 that Uncle Joe received as a benefit during his lifetime, and then the remaining balance can be distributed amongst his beneficiaries.
Wow, and that could take, well, to say the least, forever, couldn't it?
Sure, you can find that these things become very drawn out. Now that the executor has been established in Uncle Joe's example, that executor does have a duty to make sure that they're carrying out the administration of the estate as quickly as they can while still making sure that things are done correctly. So really, you shouldn't find that an executor is dragging their feet in any way or they're slowly administering the estate without good cause. They should be careful and make sure they know what they're doing, but they should also do it expeditiously so that the beneficiaries aren't waiting an incredibly long time. In New York, creditors have a 7-month period to present their claim saying, this decedent, now that they're gone, they owed me money and I'd like to be paid back from their estate. So from the time the executor is appointed through 7 months, the creditors can stake a claim. After that 7-month period, no additional creditors can kind of come out of the woodwork. So the executor will wait at least 7 months before paying off claims and making final distributions, which is why we see these proceedings take at least a year.
Well, you know what I have to tell you, in my notes here about Uncle Joe's estate, his company that he worked for was an accounting firm.
Okay.
If that makes any difference.
Sure. I mean, an accounting firm does seem pretty well suited to serve in an executor position. We're going to assume that they have some familiarity with financial matters and probably pretty good with numbers. It would make sense that they would be able to keep good records, tracking all debts and expenses, and then finally keeping track of distributions that are ultimately made out to those beneficiaries. So if I was a judge, right, and I'm taking into consideration the executors that Uncle Joe listed in his will, an accounting firm might stand out very highly because of their expertise in financial matters.
Apparently, that's what the judge was thinking, I guess, in this case.
Sure. Seems to make sense.
Yeah, absolutely. Megan, again, if you don't mind, all your contact information and where your offices are located, please.
Absolutely. So our offices, Blustein, Shapiro, Frank, and Barone, are located in Goshen, New York, and then we do have a Monticello location as well. The phone number there is going to be 845-291-0011, and our website is www.mid-hudsonlaw.com.
All right. Now, you only have one more workshop this year, right?
Right. Just one more workshop. It's on October 14th. It starts at 3 o'clock. They usually run about 2 hours, and they are free and open to the public. So I would recommend that if anyone is thinking they would like to get their estate planning going this year and they want to attend an educational workshop, then October 14th is going to be the one to sign up for. You do have to register in advance because seating is very limited. Yeah,
I remember you telling me one of the workshops you had, you could barely fit everybody in the room.
That's right. We do try to accommodate as many as we can, but, ultimately the space only lends itself to a certain number of people without everyone piling up on top of each other.
Yeah, right, which is very, very important. And also I'd like to point out to all our listeners that you are a partner in this law firm where you work.
That's right. I'm an attorney, but I'm a partner in the firm, and I work exclusively in the estate planning and elder law department of our firm.
Well, I'll tell you one thing. You sure do cross your T's and dot your I's, Megan.
Thank you. We do try.
You really do. By the way, there's a question I want to ask you. Mm-hmm. During your 4th of July celebration, did you have any corn on the cob?
I didn't this year, although I do love corn on the cob.
Oh, me too. I understand it's really, really good, so I'm going to have to get some.
I highly recommend that you do, and then report back to us. Let us know how it is.
I most certainly will. Megan, again, I do want to thank you so much for your professional expert advice and your time. It's very, very good to be able to talk to you with planning ahead right here.
Thanks, Bobo. It's always a pleasure to be on.
Yep, and you know what? Have a cool rest of the summer if you possibly can.
Thank you. Same to you.
All right, Megan, bye-bye. All right, there she goes, Megan Conroy, and she is just absolutely awesome. I'm Bobo, a fun day Saturday morning, wrapping up our planning ahead